The following IWLA webinar, Transportation Brokerage and Freight Forwarding, was recorded on December 12, 2013. All information is accurate as of that date. Hello and welcome to IWLA's Transportation Brokerage and Freight Forwarding webinar scheduled to run between 1:30 and 2:30 Central. My name is Joe DeGuzman and I am the Senior Coordinator of Member Marketing for IWLA. Today is my pleasure to introduce our featured speaker, Mr. Mark Blubaugh. Mr. Blubaugh is a partner with Benish's Litigation Practice Group, who recently was awarded the Transportation Law Firm of the Year by U.S. News and World Report. He serves as the co-chair of the firm's Transportation and Logistics Practice Group. He has litigated a wide variety of transportation and logistics-related cases in state and federal courts throughout the United States, as well as before administrative bodies. Before we begin, I'd like to quickly address protocol for the webinar. During the webinar, all participants will be placed in lecture mode and all participants' lines will be muted. To collapse the interface window on the right-hand side, please click on the orange arrow that points to the right. This will minimize that heads-up display. If you minimize that heads-up display like a normal application, you won't be able to see the presentation. At the end of the presentation, there will be a Q&A session. Please submit your questions in the questions box in that user interface window. If you have any technical issues, please use that same questions box function and I can respond to you directly. And this presentation will be distributed via email either later this afternoon or tomorrow morning. With that, I'd like to hand over the presentation over to Mark. Mark, go ahead.
Thanks, Joe. I appreciate it, and good afternoon, everybody. I certainly appreciate the invitation to speak to all of you today. The topic that we're talking about today, I believe, is an important one for a whole variety of reasons. I think that there is obviously great value to our customers in delivering brokerage and freight forwarding services. It can drive your own profitability. But there's also a lot of confusion in the marketplace about what transportation brokerage or freight forwarding really is. And there have been a number of changes that have been implemented by Congress and by the Federal Motor Carrier Safety Administration that have some real-world consequences and implications for businesses engaged in this type of activity. And there are also court cases that have changed the legal landscape regarding transportation brokerage and freight forwarding in recent years as well. So, I think it's an important topic, and I'm glad that I have the opportunity to speak with you a little bit about it today. I think warehouse operators themselves often, too frequently maybe I should say, do not always strategically think about what they truly want to be in terms of some of the other value-added services that they intend to deliver. Sometimes you find yourself simply mimicking offerings that are made by one of your competitors or someone else you saw in the marketplace. And that happens sometimes with brokerage activities. Many companies end up simply declaring themselves a logistics company or opening what they'll call a logistics division of their operation in order to provide some services to help their customers. And at the end of the day, that's how you, the business owners or managers, oftentimes view it. You're just trying to add some value for your client, trying to help them out, but you may be unknowingly creating some liability for yourself or others. And a good example is when a warehouse operator or maybe a motor carrier decides that it would be good to get into the brokerage business and simply sets up their logistics division, so to speak. But it becomes very hard to tell where the warehousing or motor carrier business ends and where the transportation brokerage business begins. And that lack of delineation can expose assets, create liability, and other issues. So what I want to do today, as you can see from the agenda in front of you, really 4 topics that I'm going to touch on. One, talking a little bit about what is brokerage and freight forwarding. What are the differences between the two? Second, what about MAP 21, the highway bill? What does that mean for you if you're engaged in transportation brokerage, freight forwarding, or even motor carriage? Third, under what circumstances are brokers or freight forwarders liable for catastrophic personal injuries? That's an issue that's obviously gotten a lot of press in recent years. So I want to talk about that topic a bit, and then kind of wrapping it up with a few comments about insurance and the types of insurance that need to be thinking about if you're engaged in these types of activities. So that kind of sets the stage for you. And this first topic about what is brokerage and freight forwarding, I want to preface it by explaining that the law does not generally define a third-party logistics provider. When we hear someone talk about being a 3PL, it can mean a lot of different things to various people. With very limited exceptions, the law doesn't provide a definition of third-party logistics provider. There are exceptions, as I mentioned, as you can see on the slide. Some state statutes might define a 3PL in a very specific context. For instance, Florida has a pharmaceutical pedigree statute that defines a 3PL. We know about the Consumer Product Safety Commission Reform Act and its definition of a third-party logistics provider, since IWLA was instrumental, fortunately, in enacting that legislation. But, that's really about the limit of it. And trade groups and professional associations all define 3PLs, 4PLs very differently. And what the law does do is define various types of third-party logistics providers. And when I'm thinking about third-party logistics providers in a broad sense, I'm thinking about generally intermediaries of sorts. So we have transportation brokers that the law does define and can sometimes be described as freight brokers, property brokers, truck brokers. It's the lingo that you usually hear. There are also various types of freight forwarders that are different. There's a surface freight forwarder. There are air freight forwarders, also known as indirect air carriers. That's really the legal name of an air freight forwarder. Ocean freight forwarders. And then you have non-vessel operating common carriers, which in most respects are much more like a surface freight forwarder than an ocean freight forwarder is. And these roles are important. These legal definitions are important because each of the roles has a different set of duties and liabilities that they incur. I'm going to focus primarily on surface transportation here because that's the bulk of the activities that you are likely engaged in. I can speak a little bit to the other subjects, certainly as the need arises, because we get involved with representing intermediaries of all kinds and involving all modes domestically and internationally. But we'll focus on surface transportation because that's really where much of the activity and questions have arisen lately. The definition you have up on the screen in front of you now is the definition of a transportation broker under U.S. federal law. So it's a person other than a motor carrier that offers for sale, negotiates for, holds itself out by solicitation, advertisement, or otherwise, is selling, providing, or arranging for transportation by motor carrier for compensation. So the key question that you need to ask yourself if you are trying to determine if you're a broker, are you arranging for interstate transportation by truck? That's the key question that you need to be asking yourself. And you'll find that there are a lot of circumstances where that might be the case. Leading it off, many of you warehouse operators out there frequently arrange for the transportation of your customers' goods by truck. And you get paid for that in one form or another, whether it's specific compensation tied to that transaction or increased business or some other types of benefits that might constitute compensation. That would be one example of a situation where you might be a broker and not truly realize it. There are arguments that one can make that you might be able to serve as a shipper's agent, for instance, rather than a broker, but that requires a very specific type of contract and kind of operational controls in place that most warehouses don't really engage in. And shipper's agents are not clearly defined in law either, and some would argue that they themselves constitute brokers. But it's important to think about this if you are arranging for the transportation of any of your customers' goods by truck. Distributors may run into this. These are distributors who don't necessarily take title to the goods to resell, but they may simply be arranging for the transportation of their manufacturer's goods by truck. They might be warehousing them and then sending them out by truck to the ultimate purchasers, once again kind of serving as that intermediary. Manufacturers sometimes end up in a purchase and sale agreement, and they are relinquishing title before relinquishing possession, and then they nevertheless arrange for the transportation of those goods by truck. Now, arguably, that could constitute transportation brokerage. There are a lot of other businesses and industries where the provider is expected to arrange for the transportation of goods by truck. It's kind of usually as a part of a broader portfolio of services. And the example I'm thinking about, for instance, would be the trade show business. There may be those engaged in putting on trade shows who, among other things, will transport their customers' setups, their equipment, their displays for their customers to get them to the trade show and coordinate all of those logistics. They may themselves arguably be transportation brokers if they're doing some of this by truck for compensation. And just a lot of other companies that call themselves third-party logistics providers that may be arranging for goods by truck. So there are a variety of contexts that you need to keep in mind when you're wondering, could I perhaps be a broker? Now, if you are a broker, you may have the question of, well, am I going to be liable for freight loss and damage or delay? So I'm arranging for my customers' goods to be moved and something goes awry. Am I on the hook for any of those damages? Generally, no. The answer is generally no. And if you had asked the question, 10, 15 years ago, it would have been almost unequivocally no. But there have been some expansion of liability in that regard. The three examples where typically liability can emerge is first, if the broker contractually assumes liability. That happens a lot, simply based on customer demands and needs oftentimes. The shipper demands that the broker be liable as if it were a motor carrier, and some brokers either unwittingly or because of business demands agree to do so. So clearly, if you agree to be liable, you're going to be liable, no surprise there. Some would argue that a broker can become liable for freight loss and damage through negligent selection of its motor carriers. There are, and this is related to negligent selection associated with catastrophic personal injuries. I'm going to speak to that a little bit later in the presentation. But this is one theory that's been used with respect to freight claims as well. I will say that, from my perspective, that is a weak claim against a broker. And that there is a federal preemptive defense that can be raised that some lawyers may neglect to do. But it's a powerful defense. It's available to brokers under most circumstances. And, I and others have been successful in eliminating those claims if they're raised. The third way is if a broker holds itself out as a freight forwarder or a motor carrier instead of as a broker. I'm going to elaborate on that in a minute, but it's a situation where the broker is not truly acting like a broker. The freight forwarder, if we think about surface freight forwarders here, I'm not talking about air freight forwarder or an ocean freight forwarder, because as an aside, the ocean freight forwarder is very much like a transportation broker. They merely play that intermediary role, arranging for the transportation of goods by ocean. So when you talk about a surface freight forwarder, though, it's a different animal. A surface freight forwarder, and this is a multi-part definition. I'm not going to read through the whole thing. But the real key here is that second bullet point, that the freight forwarder assumes responsibility for the transportation from the place of receipt to the place of destination. Freight forwarder, in other words, may be a non-asset-based provider, may not have any vehicles, just like a transportation broker doesn't have any vehicles. But unlike the transportation broker, the freight forwarder is expressly assuming responsibility, and in fact issuing the bill of lading, serving as the carrier on the bill of lading, even though they are not in fact using their own assets to move the goods in question. So when you're thinking about liability for a freight forwarder under the Carmack Amendment, which is the same statute that governs motor carrier liability, the liability is identical to that of a motor carrier, essentially. There's going to be strict liability for full actual value unless some of the traditional defenses are available. A freight forwarder can limit liability through a release rate, just like a motor carrier can, or a freight forwarder can contract around the Carmack Amendment with a specific express waiver of federal rights and obligations. That's permissible. But generally speaking, if you're a freight forwarder, you're going to be on the hook for freight loss and damage. You're going to be issuing the bill of lading as if you were the carrier. If you're a transportation broker, you're not going to do so. And think about the analog on ocean once again. And it may seem counterintuitive, but an ocean freight forwarder is more like a surface transportation broker. It is not liable for freight loss and damage, generally speaking. whereas an NVOCC, the non-vessel operating common carrier, is much more like a freight forwarder. So you can see why people, particularly when you're talking about multiple modes, can sometimes easily get confused about what they're discussing. So just saying freight forwarder doesn't accomplish a whole lot. You have to know, are we talking about a surface freight forwarder, an air freight forwarder, an ocean freight forwarder, because different rules will apply to all of them. So the question then becomes, well, do you want to be a broker or a freight forwarder? What are the reasons why you might be one and not the other? The primary distinction, as you might already gather, is what liability are you willing to bear? You don't want to be a freight forwarder if you know right out of the box that you're not going to want to incur the liability associated with being a freight forwarder or a motor carrier. If you're trying to eschew liability, you're going to want to be a broker. Of course, you have to consider the impact this is going to have on your marketing strategy, on customer relationships that you may have. Is it the sort of thing that you are able to foist off? Can you, in fact, get away with it, so to speak, just being a transportation broker? And sometimes that's based on market position, level of service, all sorts of other business factors that come into play. And then which model really most closely aligns with your operations? Are you in a position to be issuing bills of lading readily? Can you do that from an operational perspective? So, those are a few things to be keeping in mind. Now, related to this is the question of, if you believe you're a broker, for instance, do you want also to be a carrier? Can you risk being treated as a carrier? And I put this quote up on the screen for you just to illustrate. This is an observation that this court made that I think resonates, and those of us who practice in the area would agree with. The distinction between a motor carrier who provides motor vehicle transportation and a broker who arranges transportation by a motor carrier can be blurred in practice, because a motor carrier might perform ancillary tasks that are principally identified with a broker. That kind of activity happens all the time, and that blurring is something that I would encourage you to try to avoid, because there are consequences that can follow from that. And putting an example on the next slide here of some situations where that can become a problem. This KLS Air case versus Cheetah Transportation, it's from a couple of years ago in California. And you have a situation where KLS contacts Cheetah, and Cheetah maintains it's a broker. Cheetah says, look, our role was to arrange for the transportation of some flat panel monitors from Pennsylvania to California. That's what we were hired to do. KLS says, no, we hired you to actually perform the transportation. And of course, what led to the litigation is the fact that the parties did not have any clear contract. There was no written contract. This was all being done on a transaction basis, and they didn't have a master governing agreement of any kind. So in this particular dispute, the broker ends up hiring a company called Sonco to perform the transportation. Sonco rebrokers it or subcontracts it to Hemi Express to perform the transportation, and the goods are ultimately stolen, and the lawsuit follows. And in the dispute, one of the claims was, look, Cheetah, you say you're a broker, but we think you should be treated as a carrier, and you should be fully liable for this high-value loss. And the things that the shipper was pointing to were, the broker, Cheetah, issued bills of lading identifying itself as a carrier, and that Cheetah had motor carrier operating authority in the same entity, one company with multiple authorities. Cheetah also supposedly didn't identify itself as a broker. They testified that the promises made were to transport, not to arrange to transport, but rather to actually transport, and that Cheetah never told KLS that it intended to use other carriers of any kind. In contrast, Cheetah had a different version of the facts and said, well, among other things, we never exercised any control over the load. We've operated as a broker for years. We provided brokerage to KLS for years. You guys knew. We've only ever used our motor carrier operating authority one time. Facts along those lines. And the court at the end of the day said, the judge couldn't decide as a matter of law which one it was. Is Cheetah a broker or a carrier? So the judge is going to kick it to the jury. Let a finder of fact decide at the end of the day whose story is more compelling. And as many of you may expect, that's not inexpensive to go to the full extent of a jury trial to have these things determined by a group of people who don't know anything about transportation and logistics. So it can be a scary proposition with a lot of exposure. Another case I'm citing here on the next slide is from New York that was decided last year, where once again confusion emerges about is the provider in question wearing the hat of a motor carrier or that of a broker, because the liability will vary dramatically depending on which hat that party is wearing. Here we've got the shipper who enters into a series of transactions with TransPro, which is the broker, the alleged broker, to move a bunch of electronic equipment around the country. And there was a payment dispute. Shipper hadn't paid, so TransPro ends up suing. You can see there were all sorts. The late fees, or the interest on this, was greater than the principal, to the tune of almost $300,000. It was an old receivable with significant late fees and such. Shipper responds, well, the reason we haven't paid is that you lost a bunch of our DVD players on a load, and we're going to do a set-off, and we're not responsible for these freight charges. And the reason we can do that, the shipper said, is that TransPro, you're a carrier. You are a carrier. You breached the contract. You're liable under the Carmack Amendment. We don't have to pay. And here there was a trial once again, but the broker did win at the end of this one. And to give you an example of some of the evidence that came into play on both sides, the shipper submitted a couple of different types of evidence. This isn't exclusive by any means, but their warehouse manager testified that TransPro was referred to him by a colleague as a carrier service, and that the marketing materials received from TransPro suggested that both carrier and broker services were provided, and that in fact in that packet of materials that was received there was a kind of a letter of reference from another customer that characterized TransPro as a carrier/broker. There was some verbal testimony from another warehouse manager that it was his understanding, his subjective understanding, but his understanding nevertheless that TransPro was acting as a carrier, and that they never would have hired TransPro if they knew it was a broker, because they already had an existing relationship with C.H. Robinson, obviously a huge broker, and they would have had no need for TransPro, so they thought they were contracting with a carrier. Now, TransPro came back with contrary evidence saying, well, wait a minute, we gave you a copy of our broker's license and the promotional materials. We don't have carrier authority, TransPro said. If you would have looked at FMCSA's website, you would have known that we were only a broker. We gave you a copy of our insurance policy, TransPro said, and it wasn't a cargo policy. It was more akin to what a freight forwarder or an E&O policy might provide, but it was not a motor truck cargo policy. So that should have been a hint to the shipper. And there was verbal testimony that TransPro never held itself out as a carrier, and most importantly, I think, there was evidence about the booking process. And in the booking process, TransPro would regularly send emails to the shipper identifying the name of the proposed carrier who was going to perform the transportation and obtain approval from the shipper. So the court, in my mind, I think that was the dispositive factor. The court said, wait a minute, we've got a trail of emails here where TransPro is saying, hey, we're sending over carrier X, and the shipper would say, okay, we're ready, send them on over. And it was clear that TransPro was playing an intermediary role. And the bills of lading didn't contain TransPro's name, unlike the Cheetah case. They contained the names of third-party carriers instead. So in that case, the broker was able to escape liability. But there's a couple of things to keep in mind as you're trying to avoid, as a broker, being transformed into a carrier and that inheriting that additional significant liability. One, I call it the duck test. That's what the courts apply. If it sounds like a duck, walks like a duck, looks like a duck, it's going to be a duck. And the same holds true with respect to brokers as carriers. If you're a broker acting as a carrier, looking like a carrier, the court's going to say you are a carrier. So, don't let your name appear on bills of lading as carrier. If you find out, I know you don't always have control over it. It's shipper-prepared bills of lading, and your name's showing up on it. You might not know about it, but you need to stop it when you do find out about it. You got to be careful about advertising. There's a federal regulation that I cited that makes it clear that a broker cannot directly or indirectly represent its operations to be that of a carrier, and that any advertising that you have has to show the broker status of the operation. This is not a regulation that is routinely complied with, but can create liability if one does not. And you have to be careful about controlling the carrier, the extent of communications that you're demanding and monitoring that you're engaged in, what kind of information you're putting on your load confirmation sheets, making it clear that if you're giving routing information, it might be informational rather than a command, and minimizing or avoiding certain types of fines that you might impose. And this ties more into some of the catastrophic personal injury matters, and I'll talk about that in just a few minutes. But those are a couple of the basic practical things you should be keeping in mind as you're executing your brokerage operation. Moving to subject 2, though, MAP 21, and what does it mean for you? This is where there's been a lot of chatter, more than chatter, a lot of activity in recent months. This is the Moving Ahead for Progress in the 21st Century Act, the highway bill that was passed last summer, signed by the President last July of 2012. And it includes a wave of changes for motor carriers, brokers, surface freight forwarders. And I'm going to focus on a few of these that's important for you to understand. One, I want to dispel a misconception. Some people think that the statute changed the definition of a broker or a freight forwarder. And that's not the case. The definitions have remained. They are what they are. What MAP 21 does, though, is imposes severe consequences for unauthorized brokerage and freight forwarding. And I'm going to walk through some of these. And this is, I hope your ears perk up during these next couple of slides, because it's very important. Number one, there is a $10,000 per violation civil fine for unauthorized brokerage. So the federal government can pursue you for a civil penalty, in essence, if you're engaged in unauthorized brokerage. Now, that theoretically, for instance, could apply to every load that a warehouse brokers out. Every load that you are arranging to transport, if you don't have brokerage operating authority from the federal government, could theoretically be a violation and lead to a $10,000 civil fine per load. FMCSA, as well as the Transportation Intermediaries Association, is encouraging parties to report unauthorized brokerage to the National Consumer Complaint Database. The website is mentioned there. The reality, the practical reality, is that FMCSA has very limited resources. They've got an awful lot on their plate right now in terms of rulemaking apart from enforcement. And so the resources to enforce are very, very limited. And most people are not sweating a tremendous amount over whether or not the federal government is going to come in and hit them with these fines. But it's on the books, and it's a reality. And if you get on the radar of the federal government for one reason or another, you better be ready for this to come. What might be more problematic is this next part that I'm going to talk about. It might have more practical implications for you. And this is the fact that the statute says that an injured party can pursue what the statute calls valid claims against a company or person engaged in unlawful brokerage without regard to amount. So what most would agree is that this statute creates a private cause of action, a private claim, a new federal claim against a party engaged in unlawful brokerage, and that any damages certainly won't be statutorily capped because the statute makes it clear it's without regard to amount. So the reality is that because FMCSA has limited resources to police compliance, this private cause of action is likely going to serve as the more meaningful enforcement mechanism. This may be a situation where a competitor decides that concludes that you're doing something unlawful, thinks that you're perhaps just copying its business practice without actually going through the proper procedures, and decides it's going to sue you for some reason, that it believes it's been damaged by what you've done, that your competition, your unlawful competition as an unlawful broker has injured it in some fashion, and it would be able to sue you with a new independent federal claim. And to ratchet up the attention on this a little bit more, and this is where I hope all of you, particularly those of you in executive positions, really listen up. This new statute creates express personal liability. The statute states that that the officers, directors, and principals of a company engaged in unlawful brokerage are going to be jointly and severally liable for any civil penalties and civil damages imposed on the company. So whether we're talking about the $10,000 per load civil penalty that the federal government could pursue, or a civil claim of some sort that a private party has brought, if you are found liable under MAP 21, officers, directors, and principals of that liable company are going to be on the hook. Now that is something that's got to get your attention. And the statute doesn't define what an officer is or what a principal is. Presumably it's one with high-level management responsibilities. But this is real world. This is not just pie in the sky. I have already defended one such case brought under this statute that a company brought against a purported broker who did not have brokerage operating authority, and the defendant was not only the company, but also named in the lawsuit were the chief executive officer, the chief financial officer, and a director. And they also named an individual who was a kind of an outsourced temporary interim CFO. He was an independent contractor, but because he was using the label chief financial officer for a brief period of time, for about a month, they included him in the lawsuit. And all of those individuals had potential exposure to their own individual assets. The third bullet point on this slide is something that you should keep in mind in connection with that. They initially thought, well, we've got directors and officers liability insurance, so at least we'll be protected from any true exposure because they felt that they had sufficient amount of D&O insurance. However, they got into a battle with the D&O insurer because the D&O insurer said, well, under this new statute, we're not clear that there's really going to be coverage. It looks to us like it's a civil penalty, and under the policy, there's an exclusion for any government fines and penalties, and so we're not sure, even though this lawsuit wasn't brought by the federal government, it was brought by an individual. So while we might have prevailed at the end of the day, it was creating a whole separate issue that everybody needed to think about. So you need to examine your D&O policy and make sure that you've got a sufficiently broad one to provide a legal defense and ultimately any indemnity if there was an adverse judgment. So those are some things that are really crucial and key that you want to be sensitive to as you're thinking about transportation brokerage. It used to be that if you didn't dot all of your I's and cross all your T's, you might have some liability and you might have exposure, but you didn't have this kind of express statutory liability that the statute is now brought into existence with $10,000 per load civil penalty, unlimited potential personal liability, or unlimited liability for the company, and then this personal liability for officers, directors, and principals. So be very sensitive to that. Also, there's some statutory exceptions. I want to carve it out now that I've scared everybody. I want to also make sure that you're aware that there are a couple of exceptions, some of which could theoretically be applicable to you. Because some of you may say, well, wait a minute, I know some ocean transportation intermediaries, in other words, ocean freight forwarders or NVOCCs that I think are arranging for inland transportation, and they're not transportation brokers. Can they get away with that? Yes, they can. There's an express statutory exemption for ocean transportation intermediaries if they are performing inland transportation as part of an international through movement. And, there's a much deeper analysis that one could go into on all these exemptions. There's one for customs brokers, also for the indirect air carriers, air freight forwarders, as I mentioned, those that are performing part of a continuous movement that is part of one by air, if you have to move something by ground in lieu of air because of severe weather. There are some of these exemptions, but keep in mind they're exceptions. Don't assume that they're necessarily applicable. Some of them are very narrowly defined. And don't presume that just because, goods are shipped to a warehouse for future sale, that those are really part of a continuous or a through move, and therefore I'm sure I'm okay and I don't need to worry about it. caution is warranted in this area. Another issue under MAP 21 to be thinking about is even if you have motor carrier operating authority and you don't have brokerage authority, you may still have some exposure for what I'm calling subcontracting or interlining. Prior to MAP 21, there's really a bit of a divergence in legal opinion. Some people said, look, a motor carrier doesn't need brokerage authority in order to arrange for the transportation of goods with another carrier, because the motor carrier itself is already on the hook for freight loss and damage. Others said, no, they do need to have that kind of authority. In fact, the FMCSA's website has maintained that motor carriers needed broker authority if they were going to, quote, broker any of these goods. So under the new law, it's very clear that a motor carrier may not broker transportation unless they have registered as a broker under federal law. So the general rule of thumb here is that, look, if you're a motor carrier and you're not physically touching the goods at some point in the course of a move, you need to get your broker authority. If you are touching the goods, if you're moving them for one leg of the transportation, you're probably okay to operate without a broker's license. But that is the kind of the new lay of the land right now on that particular subject. And I'll have a little caveat to that in a few moments. The other issue that's gotten a lot of attention, obviously, with MAP 21 is the broker bond. And this was one of the driving forces, one of the critical elements of MAP 21. And this is the increase of the $10,000 bond to the $75,000 bond. And really, financial security is a better way to put it, because there are two ways to provide for that financial security. But I want to preface this by reemphasizing that this financial security relates to freight charges. A lot of people are under the misimpression that this somehow ties into freight claims, cargo claims. No, it does not. This is for freight charges that a motor carrier may claim against a broker for payment. So it used to be $10,000. It's been up to $75,000. Originally, there was discussion and legislation aimed at increasing it significantly higher than that. But 75 was the magic number at the end of the day. And there are really two ways to do that. One is through a surety bond. For a surety bond, as you'd expect, you pay premiums annually. You usually have to provide some collateral. You're probably going to have to, depending on the nature of your business, you may have to provide a personal guarantee. And there are a list of various approved companies that can issue these bonds that the federal government even makes available. Alternatively, you can do a trust fund. This requires a full deposit of the $75,000, but once it's there, it's there. There are sometimes less stringent investigations that the trustee engages in. It depends. I mean, if a claim is made because it's not money that the trustee owns, it may be a little bit more liberal in doling out money, but nevertheless, I have not seen many situations where either a surety bond or a trust fund has paid claims readily, and that led to some of this legislation because the fear was that these bonds and trust funds really were not meaningful ways for motor carriers to collect, and so there were some further changes implemented, and I'll elaborate on that. But when we talk about the trust fund, the statute or the regulation says, look, it can be with any kind of financial institution. Most large banks, in my experience, don't really want to get into the game. They're not interested in doing it. They don't really understand it, and they don't feel like incurring the compliance costs. Small banks might do it for key customers. They themselves, frankly, don't know what they're doing, and they don't understand what they've gotten themselves into. But they might do it because they have a business relationship, and they figure, well, we'll just agree to do it and figure it out later. I think that'll be less likely to happen going forward, just as a practical matter, because of the new risks associated with this kind of financial security instrument. But we'll have to wait and see. Group surety bonds are technically, at least legally, permissible, but FMCSA has not yet permitted them. They are considering what the implications might be of group sureties and the effect that might have on new entrants and smaller operators. So FMCSA maintains it has a statutory authority to permit that, but it hasn't happened yet. One thing that is now clear is that a single $75,000 financial security instrument is acceptable if you have one entity holding multiple authorities. You still have to file separate forms reflecting that you do have the $75,000, but you can use the same $75,000 if you've got one entity with all of the operating authorities. There may be, and there are, I think, very sound reasons for not doing it that way, but nevertheless, it is theoretically available. These surety performance standards are the other things that I think are going to probably lead other financial institutions to being a little more reluctant to step into this space. If there's a financial failure, the surety has to make sure it publicizes a claims period, has to pay uncontested claims pro rata. There's a possibility that if the surety does not pay a claim that it should have, that it's on the hook for attorney's fees and costs if the claims are contested by the surety. So it's got a little bit more skin in the game. It also has to issue certain cancellation notices 30 days before the effective date, and if the surety violates one of these new technical requirements governing financial security, it can face a $10,000 civil penalty fine or civil penalty. So it gives the sureties and those involved in that financial instrument market a little bit more skin in the game, of more of an incentive to comply and hopefully perform the job that everyone expects them to perform. A couple of other things in MAP 21 that you want to be thinking about. One is this distinctive registration numbers that are going to be coming up at a future point here. Essentially, MC numbers are going to go away, and there are going to be distinctive identifiers for brokers, freight forwarders, motor carriers, so it'll be clear, at least a little bit easier to determine which hat somebody is using at any given time. FMCSA has not yet promulgated the regulations that will set all of this forth. Transportation contracts. You now have an obligation to specify in writing the type of operating authority under which service is being provided. So it's aimed at clarity, at making sure that if you're a broker, your customer understands that you are serving as a broker in a given transaction. If you are a motor carrier, that they understand that you're a motor carrier for that transaction. That's not a practice that all in the business have uniformly implemented in the past, so you need to be aware of that. Minimum experience levels for new entrants. Going forward, a new broker is going to have an officer who possesses 3 years of relevant industry experience or some functionally equivalent level of knowledge of rules, regulations, and industry practices. This is aimed at kind of harmonizing surface transportation with ocean transportation. The Federal Maritime Commission has long required ocean transportation intermediaries to have a similar experience level when obtaining operating authority. So going forward, this is what the federal government is going to do for surface transportation brokers and freight forwarders. And the regulations and forms and such, once again, have not yet been promulgated and issued, but it's going to be coming. So if you're already in, you won't need to worry about that. There's going to be some new renewal requirements of registrations going forward. As you can see, a couple of years from now, you're going to have to start renewing your operating authority where you didn't used to have to do that. I wanted to just highlight there was some confusion in the market, I think, about some aspects of the uniform registration system that just went into effect. There's really no current obligation for brokers or freight forwarders to file any kind of biennial update with FMCSA. That doesn't kick in for another 2 years. There's going to be a new form, this MCSA 1, that can be used to do that. Motor carriers did have to, as of November 1st, submit, and they're subject to new penalties. But if you're a broker or a freight forwarder, don't be sweating over that. It was not meant to apply to you. Up-to-date registration information, you now are going to have an obligation to notify FMCSA, and FMCSA will have to make public any changes to certain types of essential information about your operation, addresses, etc., so that information is as up-to-date as possible. There was some guidance that was issued in September of this year that provided a 60-day phase-in period, because even though MAP 21 was enacted last summer in 2012, there were a variety of effective dates that kicked in over time, the most recent of which was October 1st. and that was the one relating to the bond, among other things, and gave people a lot of anxiety and angst as that date approached. FMCSA took a look at it and said, look, we know people are still getting up to speed, and there's some confusion, so what we're going to do is phase in enforcement. And starting in October, we're going to start monitoring this, and as of November 1st, we're going to mail notices to anybody who hasn't met this $75,000 financial security requirement. And they did issue those notices, and they were giving people 30 days to fix it, to get their increased financial security on file. And they did, in fact, begin to do that. And as of maybe a couple of days ago or so, I think I read there were about 7,500 brokers and freight forwarders who have now had their operating authority revoked. 7,500. Now, there can be a question as to whether, how many of those were really operating in the first place. I mean, they may have been, many of them may have already been defunct long ago. Some will argue that no, it included a number of worthy, legitimate brokers that, for whatever reason, couldn't get the $75,000 financial security instrument. So, there is a question about it, but there's no doubt that it has eliminated about 7,500 brokers and freight forwarders so far from the federal marketplace. Once again, we can debate the real-world implications of that. With respect to this interlining question, the convenience interlining that I spoke about a moment ago, FMCSA recognized this was going to be a change to the industry. They're not sure how widespread. They said they weren't really sure how widespread this practice of brokering, so to speak, is among motor carriers, but they wanted to think about it, examine it, so they're going to phase in enforcement. And keep in mind, this is just the federal government with respect to the $10,000 civil penalty saying that they're going to phase in that enforcement. It doesn't eliminate a private party's ability to say, hey, I'm going to sue you, motor carrier, for engaging in convenience interlining to my detriment. Somehow that's injured me, and therefore you're on the hook, and so are your officers and directors. That can still go ahead. It's just the federal government saying that they are not going to use their police powers to impose civil penalties until they have a period of time where they accept these complaints, and they're going to evaluate the data, work with industry groups, whatever that may ultimately mean, and develop a comprehensive enforcement program. So there's going to be some time for that. A word about this lawsuit that the Association of Independent Property Brokers brought to essentially prevent FMCSA from implementing MAP 21 bonding requirements. That organization, it's a group of what some would say would be smaller brokers who were troubled by MAP 21. They said, look, FMCSA is implementing new requirements without going through formal rulemaking. That there's some obscure notations on a website, and that's all the notice that is being given. This is not appropriate. FMCSA says, no, you guys are blowing it out of proportion. The statutes in MAP 21 require these changes. There's no administrative regulatory discretion. We're just doing what Congress told us to do. And just at the end of last month, the Court of Appeals agreed with FMCSA and said, we're not going to enjoin anything. This is required by statute. So that's where that lawsuit stands, if you've been wondering about it. So a couple practical takeaways here. If you are arranging for the interstate transportation of your customer's property, get yourself a brokerage operating authority. If you are a motor carrier and you're interlining or subcontracting any appreciable volume of freight, you should really get brokerage operating authority. Avoid the $10,000 civil penalty. Avoid the possibility of a private lawsuit. Make sure that you're updating your agreements, load confirmation sheets, rate confirmation sheets, related documents, and protocols in order to comply with these disclosure obligations, making it clear which hat you're wearing at any given time, and make sure you educate your sales team about the importance of understanding which hat they're really using at the end of the day. We only have 10 more minutes, so I'm going to flip through this pretty quick. And this wasn't intended to be the focus of the presentation anyways, but I wanted to at least speak to it. Broker liability for catastrophic personal injuries. I started with this quote from this consultant study recently. It was done last year saying, hey, we're seeing an increased number of multi-million-dollar legal judgments against shippers as well as brokers that are a consequence of accidents involving motor carriers they select. And I think many of you have seen these cases out in the press. There's been an evolution over the last 10 years or so of these types of claims, starting with the negligent selection, what I'll call the negligent selection cases, beginning with Schramm. There was a famous case, Jones, and then Heil. each of which involved a claim that the broker somehow was negligent in selecting its given motor carrier. And each of these cases involves individual facts and circumstances, of course, but it was the first time, Schramm was the first one where the court really said, yeah, we're going to possibly recognize this claim, that we're going to let it go to a jury and see whether or not they think a broker has been negligent. Heil, which was the most recent of these cases, ended up with a $1.6 million, I think it was $1.6 million judgment against the broker for negligently selecting a carrier who apparently did not have active operating authority at the time, didn't have proper insurance, had safety problems, and the jury said we're going to impose punitive damages against the broker as a result of this. The next type of theory are these respondeat superior cases. You often hear them called vicarious liability, essentially saying, carrier or broker, we're going to treat you as the carrier. We think that you've exercised so much control over the carrier that you should be liable to the same extent as the motor carrier. And in the Heil case, which came out of Oregon, the Spruill case, I was talking about Heil again. In the Spruill case, this was a situation where C.H. Robinson was alleged to have exerted too much control over the carrier in question, and it did it in allegedly in a variety of ways by kind of imposing, among other things, fines on the motor carrier for not meeting certain criteria, not reporting in frequently enough, not getting to destination by a certain point in time. And the court said, look, we think this is troubling. It put the driver in a tough spot and either was forced to violate hours of services laws or make no money at the end of the day. And there were other specific facts in Spruill that led to that conclusion as well. C.H. Robinson was supposedly the owner of the potatoes in question, and that led, for some reason, the court to believe that that should be more problematic. C.H. Robinson was paying the driver directly rather than going through the motor carrier. Some of the routing direction didn't say it was for information only. It suggested it was more like a command. So that created a significant liability, $27 million judgment taken against C.H. Robinson in that case. Joint venture theory has been another one. This Hoffman case was the most recent. That was out of Illinois just last year. It resulted in a $27.6 million judgment against the shipper, carrier, and broker. All were found to be jointly liable for that amount. Essentially, the court said, we think you're all involved in a big collective joint venture and should be on the hook for the activities that took place. Other theories have been tried with varying levels of success as well. There's a little bit of good news that this year there was a case that came out, this Hayward case. Not a lot of facts about it, but once again the claim was, hey, there's a third party injured, and that the broker should be liable because it hired the trucking company, and it shouldn't have hired that trucking company or exerted too much control over that trucking company. So the plaintiffs tried all these same theories that I've just been talking about. The court rejected them all, said they understood that those cases were persuasive, but they were different. And for instance, distinguishing it from Spruill, they said, well, look, here the load wasn't owned by C.H. Robinson. The load wasn't being delivered to Robinson's warehouse. There were no fines being imposed here. The driver didn't negotiate directly with C.H. Robinson. They worked through the motor carrier. Robinson didn't pay the driver directly. The directions on the load confirmation sheet were very general for informational purposes, and that any check-in obligations were very modest. So a couple of points to think about, housing your brokerage operation or freight forwarding operation in a different entity. I think that that's very valuable. It can certainly protect your assets and ultimately the overall enterprise value. I think that there's obviously still legal theories that people try to use to permit an injured party to pursue a warehouse operator, for instance, that's operating a transportation brokerage, even if it's a separate business, but it will make it more difficult through the formal separation of the business units to penetrate that. And it also, I think, by separating your entities, forces you as an operator to identify with clarity which service you're providing in a given transaction, because disgruntled shippers, customers inevitably claim that the provider represented itself as a motor carrier when in fact the operator believes it was entering into a brokerage arrangement. So you need to separate that out. I think it also forces you and your whole sales staff really to think clearly about what service you're offering. It might permit you to track P&L a little bit more clearly. And it shows that your staff, frankly, that you take the brokerage, enterprise, and freight forwarding business seriously if you are creating a new entity and doing business in that regard under that new entity. So a whole variety of reasons. It might also help with your insurance rates. Second, adopt a good broker or shipper-broker contract and broker-carrier contract. The biggest area of exposure for brokers, and take this away if nothing else, is the disparity between a shipper-broker contract and a broker-carrier contract. Situations where you as broker make certain commitments to your customers and then fail to extract similar commitments from your carriers, and then you're stuck in the middle. You promise a carrier, or you promise your shipper that you're going to use carriers having $250,000 worth of cargo insurance, and then you go turn around and you hire a carrier with $100,000 of cargo insurance, creating exposure for yourself. Don't act like a carrier, like we talked about. Adopt a carrier selection protocol, and we could have a whole separate presentation on that, what the elements may be. There's a whole spectrum of opinions on what the extent of a carrier selection protocol should be, but at the very least, you should have something in place to make sure you're doing a bit of due diligence on your carrier to make sure that they have valid operating authority, insurance, etc. And then obtain proper insurance. And I'm going to wrap it up here so I can answer a couple questions. A couple of things about insurance that you need to think about if you're a broker. Contingent cargo, it comes in all shapes and sizes. It doesn't mean the same thing to everybody. There are very narrow policies that may only apply if the other policy is the motor carrier's policy is illegal or the insurer becomes insolvent, for instance. There are very broad forms of contingent cargo that may provide for greater limits than the carrier and provide an immediate defense, for instance, and may not be follow form. In other words, they may cover exclusions that are carved out of the motor carrier's cargo insurance. A broader form is the E&O. I mean, to have a broad E&O policy may help, and those two can come in different shapes and sizes, obviously. If you can get a broad one, such that even if the carrier never actually gets custody of the goods, that would be helpful in light of all of the cargo theft cases that have emerged in recent years. It'd be nice to have an E&O policy that will protect you if a masquerading carrier shows up at your shipper and takes the load. Contingent auto policy, which is a policy available to address some of these catastrophic personal injury cases that I've mentioned. Once again, they can come in different forms and sizes. Narrow ones might only apply if the motor carrier's policy is inadequate. A broad one will actually defend and pay claims against you, the broker. And then there's another product called, what I've seen at least out in the market, called truck broker liability insurance, which is really a form of primary coverage that provides defense and indemnity and even permits you to list your shippers as additional insured, I'm told, that Chartis and Markel have put out. So there's different things in the marketplace to be considering.
Thank you for listening to this IWLA webinar. For more information and for more webinars, please visit IWLA.com.